which is the classification of human rights on the basis of the distinction between respect, protection, and fulfillment. Okay? Again, this is, in a sense, a constitutional tool. Why? Because that tool, that classification, would work in exactly the same way, both at the domestic level and at the international level. Okay? Next week, we will move with a number of sessions concerning how human rights operate at the international level. Okay? Which means that we will see how human rights or international law needed to be adapted, changed, so that they can produce effects in a different legal system, the legal system of international law. But for today, we continue with the constitutional function of human rights and the difference between respect and protection. Okay? Clear?
Yes.
Okay. As I did the previous time, I'll try to do this not in abstract and theoretical terms, but we will pool those principles, those rules, by discussing them in the context of specific cases. Okay, so I gave you 3 cases to study, and I would like us to start with Fadegeva. Before that, just to make one announcement, now that many of you came, which was not the case at 9 o'clock in the morning. If you remember, for those of you who were here in the very first session, I told you that we will have 2 guests for these seminars coming from the University of Manchester. The first one is coming next week. So the next seminar, I'll co-teach it with Dr. Soufiane Droubi. He's a Brazilian, in spite of the name is Lebanese, but he's Brazilian. A Brazilian scholar and an expert in international law and international human rights protection. So the next session we will co-teach it together. And I will upload today the reading. There will be one case that he asked me to give to you. It is a lengthy one, but he sent me instructions as to where he wants to focus. I will send you another case, I will send you a paper also to read, and this will be your preparation for next week, but give priority to the reading given by Soufiane. I'll send you an email this afternoon to explain everything, okay? So, Fadegeva, the facts of the case. What happened to that poor lady? First of all, who has read the cases? Yeah? All of you? Someone back there? You read the cases? Yes? Okay. What happened to that poor lady? The facts of the case.
There was a factory nearby that was producing toxins. The local Soviet said they would relocate citizens because of the pollution. The factory shouldn't be built because
Alert from your...
the factory shouldn't be built because the restrictions placed on it said within a certain area you can have a population, but the local authority said, well, just put it in the middle of the city and all the voters. The citizens complained, promised to relocate them. Fadegeva was unfortunately one of the last to be on the list, so she took the course that you want to relocate me. He said, yeah, we'll relocate you. We put you on the special agent list. Then they forgot about it. Apparently there was the special agent list didn't exist, so she put on the general list. She then complained, went back to court because you have to look after it, and it just basically got swamped in paperwork.
Okay. So, thank you for this. Bottom line is you have someone who lives at Fadegeva. She lives in a flat, and that flat is very close to a steel factory or something like that. There is pollution. This means that there are dangers for her health. People living in that area complain and they say, you know something, this is against our human rights. Okay? This raises issues in terms of health, life, well-being, home. Okay? So, we want you to do something. We want you to protect us. This happens, she moved in that flat in mid-70s. So most of you, including myself actually, were born at that time. Okay? And the court delivered the judgment when? The European Court of Human Rights? When did the court deliver? 2005, which means that for 30 years she was living in that area. Okay. There is a preliminary issue there, which is what rights are affected. Okay. We will not focus on it today. This is something we will be discussing in more detail, most probably when we will be discussing the making of international human rights law. But the European Convention of Human Rights that we discussed again last week does not have in the Bill of Rights, the list of the rights contained in the European Convention of Human Rights do not include health. However, the European Court of Human Rights has interpreted, has applied Article 8, the right to private life and home, in a very expansive way. And by home, it also means, through home, through the right to home, it has also managed to examine cases of environmental protection. This is an environmental protection case, okay? But this is not where I want us to focus. Before engaging with the technicalities, the technical dimension of the case, do you think that Ms. Fedegeva was right? Yes or no? What do you think? We'll start to...
Repeat the question, sir. I was looking at the article. Can you repeat the question?
The question is, forget the law for a minute, and let's discuss, the case from a moral point of view. Do you think she's right? She's someone who lives in an area which is polluted, and says, okay, get me another house. This is fine.
The government made an argument that she could have moved, like she did in council property, and she could have moved.
Yes, that's a legitimate point. Do you agree with that?
Yeah, I think that.
So first question is, do you think she's right or wrong?
Yeah.
Right. Just raise your hand. Who says right? Right. Okay. Any communists? Last time you were torturers. Today you're communists. Okay. Who says he's wrong? Okay, not the communist, the capitalist. Why?
Well, basically, she left it too late.
Mm-hmm.
They could have complained straight away or within a reasonable time.
The complaint, it is not only Fedegeva, it is all the population which is affected by that. They complained quite early, which means that, and then it took something like 30 years because they had procedures before domestic courts and then the administration, they wouldn't cooperate, they wouldn't comply with the judgments of the Russian courts, etc. So, from her side, she can make a legitimate claim and say, you know something, I've been trying to change the situation for a big number of years. But
who doesn't research the area before moving there? She moved there in 1982, decree to move people up, and that was passed in 76. Why would you know when we moved?
Unless if you're a worker and you move there, it was a distance of something like 500 meters. Because this is an opportunity for you to work and to earn your life and not to sleep on the street.
You don't need to live 450 meters from your workplace.
If you don't have a car, if you're in the 70s, different regime.
Even so, I think you can't argue pollution and to be moved when you knowingly moved there.
Well, if it's council housing, that's a different situation entirely, because you don't really get a say when you get a council house, when you get placed, so it's a good chance she didn't have any say in the matter where she was going to live.
Plus it is in the 70s in the Soviet Union. But there are similar cases Actually, there is a very nice short documentary on YouTube. There is a similar steel factory somewhere in Sweden, I think. But people are willingly go there, etc. And then they cooperated with the corporation, and the corporation is moving the entire town, okay, 2 miles away or something like that, so that they don't suffer because of the pollution. But in this context, she's a poor person, she's a worker, she lives there, and she says, I don't have the means to live anywhere else. For me, it is between being a homeless person and living there, and breathing all that, dirty air. Is he right, yes or no?
I think the company is wrong because they knew that they have the security zone.
Mm-hmm.
They define it as soon as they create this. They define one security zone. So they built all flats for their workers in the security zone. That nobody should be there.
Okay.
So I think.
Good point. Any reactions to it? Maybe we should put the blame not on the state, not on Fedeva, but on the corporation, because this is a private corporation, and there are rules in Russia. There was a security zone, so that a buffer zone, so that people don't suffer from the pollution. In spite of that, the corporation, A, it polluted, and B, it didn't take the measures that should have been taken in order to protect the environment and the life of the population there. Should we put the blame on the corporation?
I think that not completely, because the state here has a role to play, and the state should have told the corporation not to build the house in that zone, but they have to also look for the protection of the rules and the law and the people. So here's one of the rules that we were looking from the reading in the basic book, that the state has a duty to protect and also to check that the private individuals have to look after the law and the human rights as well.
So, just a moment. So far, it is Fedegeva's wrong, it is the corporation's wrong, it is the state's wrong. Okay? Anyone else? I'll come back to that question.
I think even though the company had been privatized, but it was a private company that was operating and its effects were affecting the environment. At that point that it starts affecting the environment, the state has the duty to step in and to place regulations as to...
So, same logic.
But I would place the blame on both the private company and the state.
Both against the private company and the corporation.
I agree.
Do you all agree with that?
Yeah, I agree.
Yes? Yes?
Isn't polluter-based principle a general principle of law and the environmental law? So it's the responsibility of the government to ensure that the corporation is held liable.
Yes, it is aligned with these two previous points, okay? Do you see any reasons? But we have a special seminar on it, okay? The very last seminar is on economic law and human rights. But this is a good opportunity just to raise the issue, raise the question, and then we'll discuss it in week 12. Do you think that... so what you're describing me is this. This is the state. No way. Postmodern. It's fracture. So anyway, this is the state. This is a corporation. Let's call them an individual, a private person. And that corporation is causing a damage to another individual. Okay? And what you're telling me is that the state should interfere in order to protect that individual from that individual. Am I right? Yes? I'll return to this. But before that, let's link this with economic law. So yes, I agree with you. In principle, the state is not neutral, even when it is not causing directly a harm, a damage, a breach of human rights. It still has a role to play. How? By interfering in that dispute and regulating the conduct of the corporation so that Fedeyeva is protected. Is this what you told me? Do you think that it should shut down the corporation? Let's say the communists. What are the communists? Shall we shut down the corporation?
No, I don't think. There's no reason to shut down. Just put in place measures under which the corporation can operate under that still respects and protects the people living around the
What's
corporation.
a corporation? Corporations are nasty, they're filthy, they want to make money, they pollute the environment. Why not to shut it down?
It's not proportionate.
It's not proportionate. We'll come back to that. Thank you for this point. Yes?
It has to be said also that the corporation was pretty important for the economy of the state.
Uh-huh.
For the
So
production.
what?
Right to
And for the people as well.
Right to employment?
For people as well.
For people as well? Okay. So keep that idea in mind when we will be discussing in week 12 economic law versus human rights. There is a tendency, actually there is a species of lawyers, okay? They are called human rights lawyers, okay? Who think that everything is human rights, everything that goes against human rights, we should just demolish it, okay? No. A corporation has also a very important role to play in terms of human rights. Why? Because private economy means employment, means growth, means we pay taxes. And this is somehow returning to the society. So the idea here is that we, and thank you for the point, should maintain a balance. It is a question of proportionality. Okay? Yes? Fine? We have in reality a dispute between two individuals. This could be a tort case. This could go before domestic courts as a tort case. It could be a criminal law case. Fedeyeva could sue before domestic courts that corporation. Why? Because they are threatening her life, etc., etc. This would be a different dimension of the same case. But for human rights purposes, we take that dispute between two individuals and we transform it into a dispute between, so let's put this is a corporation and this is Fedeyeva. We transform it into a dispute between the state and Fedeyeva. This goes back to what we were discussing in the very first seminar when I told you that human rights originate from domestic constitutional law, and initially what their purpose was to guarantee that the state will treat in a way that is compatible with human rights its individual. Let's make a break here. Can you identify the key difference between Leila Shahin, that we discussed last week, and Fedeyeva? The difference is here. Can you identify it?
Wasn't Fedeyeva represented by a group? Shahin.
Okay. 1, 2, 3, 4, 5, 6, 7. One group. 1, 2, 3, 4, 5, 6, 7. Two groups. 4 of you. Another group. So it's these two. I want you to compare Leila Shahin with Fedeyeva. And I want you to find both similarities and the key difference. You're actually, yeah, it's this group over there, and you are over there. Okay? Fine.
What is
the last week?
Yes, the last one.
Whatever university case.
University.
The one he said, Layla Sakin. I'll put it in the email. Let's just see. But I think it was the one where the lady was wearing the.
Oh yeah, hairstyle.
I think so.
Yeah.
Well, let's just see. Did you get the email, Dana?
Other points?
As they were saying, the classification of the right is quite different. So the one fits in the liberty category, whereas the second one is in the equality.
So one, no corporation or third party. Second, you say that which case is liberty, which is equality?
Layla Sahin liberty
Okay.
and Layla equality.
Can you remind people why this is relevant, going back to your notes from the first seminar?
In Layla Shahin's case, it was the issue of deviation is from the second generation of human rights. That is the political and civil rights were alleged to be violated. But and the state had the obligation just to ensure that these rights will be exercised freely and without any interferences. Whereas in the Fedeva cases, the state palpably failed to ensure the third generation of human rights, that is ESCR rights.
So, different generation of rights. Just to make sure that everyone follows, I'll make a step back. Liberty versus equality. If you
Negative versus positive. whereas
negative versus positive, yes.
In liberty, state abstains from doing certain things, whereas under equality, state is bound to provide certain things, like social and economic rights and
Negative right, positive right.
Okay. So just for those of you who were not here in the very first week, when I was telling you that human rights originate from domestic constitutional law, etc., etc., then I linked this with the French Revolution, okay? And if you remember, I asked you to tell me what the three stripes in the French flag mean. And you told me liberty, equality, and solidarity. Liberty, I told you, is associated with not the second, but the first generation of rights. Okay? So civil and political rights are associated with liberty, and we want the state to have a negative role. Don't touch me. Don't interfere with my right to wear a headscarf. Do not get into my house. Do not torture me. Whereas equality has a positive dimension. We expect the state not to be neutral, but to provide, to give. Okay? Clear? So you're telling me the first one is that we didn't have a third party, no corporation involved. The second one is that these cases are associated with different principles, which means that the first is a negative case and the second is a positive case, yes, and that they also belong in different generations. The first case, Layla Sahin, had to do with civil rights, whereas this one has to do with the right to environment, etc., under a label, under a false etiquette, under a false label, which is the right to home. Okay? If you remember at the beginning, I told you that the European Convention of Human Rights does not protect the environment as a human right. However, they have interpreted Article 8 in an expansive way so that it covers also environmental protection. Okay? Yes? Other key differences.
In the Layla Sahin case, there was a clear duty to respect a right from the state. Since the state, it was between the state was the other party, there's a duty on the state to refrain from directly interfering with the right.
So Layla Sahin was a case of respect,
right,
whereas this case is
a duty to protect. Requires the state to take measures to prevent third parties from interfering with the enjoyment of the right.
And respect is negative, whereas protection is positive. Okay? Any other points with regard to differences? Any other points?
We were discussing the role of proportionality, but we didn't really finish that one. So, because I think in the second case, we said it wasn't proportional. But
In this case, do we have proportionality? Yes or no? So in Leyla Sahin last week, for those of you who were not here last week, this is a case where the Turkish state said you're not allowed to wear a headscarf in universities. This is an interference with the right to the freedom of religion, and then we assessed whether this is lawful on the basis of proportionality, if there were good reasons justifying why we should limit one person's the right to express, manifest his religion. Okay? This is proportionality. In this case today, in spite of the differences, that this is a case of protection, a positive case, as opposed to a negative case of respect that we discussed last week. Do we have proportionality? Does it apply in the same way? Yes? No? Let's make a step back. This is the corporation. Shall I shut it down? No. Why?
Haven't done anything wrong.
They haven't done anything wrong? Yes? They have done something wrong. They have polluted the environment.
No, they had the license.
Got
permission of the state.
Other reasons. Why not to shut it down?
The economy, the jobs they create and the money it brings.
They do something good for the society.
Yeah.
Plus, they produce steel, and we can buy it here and build cars or whatever. Okay. Second reason. Other reasons. Other reason? Can you think of any other reason?
There are other ways. They say that their machines are too old and they could change it to make it better.
Okay.
Don't pollute so much.
There are other ways, which means that you can avoid shutting down. This is proportionality. Okay.
Yeah.
So in both cases, proportionality applies. Another reason why it is not a good idea to close the factory.
Wasn't there a sanitary security zone that had been put in place?
Leave this aside for the moment. Imagine I come to you and I tell you, well, it's polluting the property, it is poor health, etc. Plus, I don't like them, they're capitalists. Let's shut it down. Would you shut it down?
No.
Why?
For obvious reasons that have been said, it's crucial to the economy.
It's good for the economy, etc. Imagine that we're very good friends and they manage to convince you to shut it down, okay? You are the lawyer of the factory. What would you tell them then to do? Imagine you're advising the lawyer, the attorney of the factory, and the Russian government shuts it down. What would you advise the factory to do?
Provide compensation
Why compensation?
in order to keep things running. In order to keep.
We want to shut it down. We don't like it. Why we need to give a compensation?
It's a
So if you-
private place.
So what?
You are their owner.
So what?
So you have the rights to.
Right to
have it. It's a private
Property.
Property. Yeah.
property. By this, what I mean here is that the state has a duty vis-à-vis Fedeyeva, a positive one, to protect her, to make sure that she's living in a healthy environment, etc. At the same time, what the state will do against the corporation should not result in a breach of the human rights of the corporation, of the owners of the corporation. This is why we need to strike a balance. This is why proportionality applies. Those two entities have a conflict of interests and a conflict of rights. It is my right to property, it is my right to operate and produce steel and make money. And it is my right to live in a safe home, in a healthy environment. The state is in the middle. The state needs to guarantee that both are protected to the extent that this is possible. And this is how proportionality applies. So, that corporation too has rights that need to be protected. And the state is in a very difficult position. It should protect the one, but in order to protect Fedeyeva, it might have to go against the corporation. In that case, it would be a negative, a positive right. I need to do something to protect you. But as a means to protect you, I might interfere in a negative way with the rights of the corporation. Do you see what I mean here? Yes? All of you? Sure?
I don't really get the last part of the negative way to the situation.
Okay, forget the terminology for a moment. Is this a dispute between two individuals? In reality,
Well, yeah.
it could be a tort, it could be a criminal law case, okay? Because of the human rights dimension, we have to take this and transform it into a dispute with the state. Fedeyeva will have, as in this case, will have a claim against the state. Why? Because the state was negligent, because the state did not protect her. How? By regulating the conduct of the corporation. If the state would not maintain a balance between her rights and the rights of the corporation, and in order to protect Fedeyeva, it would shut down the corporation, then the corporation would have another claim against the state. Why? Because you have confiscated, you have expropriated my property. Which means that the dispute between those two requires the state to protect her without limiting in a disproportionate way the rights of the corporation. Which means that the state is in a very, very difficult position. It is sitting on the fence. It has to protect the one, but not in a way, in a disproportionate way, that would affect unreasonably, unnecessarily, the rights of the other party.
And in addition, if the state do something like that, the part that is agreeing is going to be in a very difficult situation as well, because it's the employment, you know.
So general
people,
interest.
Yeah. It's not just a bad things for the company, but for all
the society.
The society and
so
the employees.
Good point. It is company plus general interest. General interest will be the good of the society. Okay. This is the drawing for Fedeyeva. Let's go back to Leila Sahin. This is the state. This is the individual, Leila Sahin. Someone said that there is no corporation, no third party in Leila Sahin, and I told you I will prove you this is not the case. Where is the third party in that case? So, indeed, there is no corporation.
The society?
The society. We applied proportionality because we wanted to balance the rights of Leila Sahin with general interest, and general interest means many other individuals. So the logic is in both cases the same when it comes to proportionality. Proportionality means that the state has a duty to, when doing something or abstaining from doing something, depending on whether it is negative or positive, it has a duty to take into account the rights and interests of thirds, of the society. And this is the function of proportionality. Okay? So, Leila Sahin's rights have to be balanced against general interest, and this is what proportionality is. Next question for you. We have established that Leila Sahin was a negative case, a case of respect, whereas Fedeyeva is a positive case, a case of protection. Clear? Two different points. The first one, in Fedeyeva, who has caused the wrong? Who is responsible for it? The corporation. In Leila Sahin, who has caused the wrong? Who has told her you're not allowed to wear a headscarf? The university, which was a public university, so the state. The difference is a difference of attribution. If the violation, the interference with the right is caused, is attributable to the state, this is a negative one. If the wrong, the problem, the interference with the rights is caused by a third person or a general situation, I can give you an example in a minute, that cannot be personified, I'll give you an example in a minute, then it is a positive case in the sense that the state can say, well, I didn't do anything against you. Well, that's exactly the problem. I was expecting you to do. I was expecting you to protect me. I was expecting you to regulate the conduct of the corporation. Okay? This scheme here, we call it indirect horizontal protection. Why? Because it is a positive case, because it is a case, a dispute between individuals, so this is horizontal. But this indirectly is transformed into dispute with the state. So this is a horizontal, a dispute between two individuals that is transformed into an issue of human rights protection. Whereas this one is clearly a vertical one. The state is directly interfering, is directly causing the problem. Clear?
Did you say horizontal?
Indirect horizontal. Or horizontal, I mean, the old school of thought would call it indirect horizontal. Now we tend to simplify things. It's like language sometimes. We write it in the simpler way. So horizontal, whereas this one is vertical. Clear so far? Any questions? Questions? No? Okay. What I want you to do is, I will ask you to work again in groups, and let's try, based on Fedeyeva, based on the differences between Leila Sahin, let's try to theorize. Let's try to go to a level of abstraction and generality that will allow us to identify the differences between negative and positive, or respect and protect. I want you to work again the same groups, and I want you to try to identify the differences in the logic, the differences in the way human rights perform, the differences in the terms of what we expect the state to do or not to do, plus the difference in the terms of criteria we apply in order to assess whether there has been a violation of human rights or not. I'm telling you beforehand that these two, negative and positive, or respect and protect, they're in a sense synonymous, okay, correspond to two entirely different mindsets. Okay, so if you're a lawyer practicing tomorrow, or if you're a judge, and you have a human rights case, the very first thing you have to do in your mind is to say, is this negative or positive? Because if it is negative, the rules that you will apply, the criteria you will apply, are different comparing to whether it is positive. So the very first question you have to address is whether the facts of the case are raising a negative or a positive human rights issue. And then the pathway differs. Clear? Yes? So I want you to identify the differences between the two, and hopefully, if we have time, I hope we will have the time to do this, by examining the Valianatos case, I will also show you why it is so important to distinguish between the two, also in practical terms. Okay? But for the moment, let's theorize. Okay? So, one group, two groups, three groups, the differences between negative and positive. You are with this group over there. Okay?
Do you have a pen?
Yeah.
No, I think this one is going to be much easier. I just...
What just popped? It's fine, it's fine. It's fine.
Thank you so much.
You want to get a university charge now?
So he wants us to identify the difference between negative and positive. So on the one hand, negative.
You remember that I told you about the French flag and liberty, equality, etc. And liberty means freedom, so negative. Equality means positive, to give, to provide, etc. This was initially associated with certain families of rights. So initially they said that, so this is the French flag, it's liberty, equality, and solidarity. Initially, they said torture, prohibition of torture, is an issue of liberty. Do not torture. Religion, expression, freedom of expression. And then they said, right to health. I need to provide, I need to have hospitals to pay for it, etc. So this is an issue of equality, okay? Education. So for a number of decades, human rights lawyers, we were thinking along these terms. This was the classification we had. Torture, religion, expression, etc., etc. Negative, we want the state to abstain, okay? We want the state not to do something. Hands up. Whereas when it was coming to health and education, we wanted the state to provide, to give. This is an issue of equality. This is a different role. And then we had let's forget who did this, by an academic, he came with this suggestion. He said, well, all human rights, irrespective of whether they are civil or social, irrespective of whether they are first generation or second generation, irrespective of whether they are associated initially with liberty or equality, all human rights produce effects: respect, protect, fulfill. The first being associated with liberty, the second with equality. So this has to do, for a number of years, we were making a false classification, a false dichotomy. And we're saying civil rights, they are only negative, whereas social rights, they are only positive. The theory of respect, protect, fulfill, what it does is that it applies across all areas, all families of human rights, and all human rights, irrespective of whether they are civil or political versus social, they all develop effects of respect, protection, and fulfillment. And when we will be doing the ICCPR, the International Civil Covenant, the Covenant on Civil and Political Rights of the United Nations, and the Covenant on Socioeconomic Rights, so second generation rights, we will see that both families of rights develop effects under respect, protection, and fulfillment. Okay? So this has to do with the indivisibility of human rights. Irrespective of whether they are civil or social, human rights all develop these three main effects: respect, protection, and fulfillment. The third one is less important in a sense. Why, we will see. But let's identify the differences between these two, but keep in mind that this scheme, what we will do today, applies to all human rights. Torture, that we did last week, plus environmental protection that we are doing this week. Clear? Which means that you told me the difference between Leila Sahin and today's case, Fedeyeva. No third party, proportionality applies always, unless if it is an absolute right. Different generation, I think you said this. Yes, but this is an old scheme. Why? Because irrespective of what generation, what family of rights you belong to, the same logic, the same scheme applies, and the important thing is to distinguish between respect and protection. Okay? Clear? So, just give me differences between those two. The key differences.
Could it be that the negative rights to the duty to respect are immediate rights that should be realized with an immediacy, whereas the positive rights to duty to protect are subject to progressive realization when there's available resources?
Progressive realization, I would put it here. Okay? And you will see, so I'm running a bit in advance. Sometimes it is really difficult to distinguish between those two layers. This one, progressive realization, would be the borderline between these two. But let's put it here. We will come back to that later on. In simple terms, for you to, so that these acquire also a practical dimension. What is progressive realization?
It's oh, sorry.
I need to protect your life, okay? To protect your life, I need to have policemen, I need to have a fire brigade, I need to have people who are trained, I need... All this, you cannot do it from one day to another one. It is a process. So this one says that states should gradually fulfill, should gradually develop the necessary apparatus and abilities so that they can more and more increasingly protect human rights. So, training of policemen, buying new police cars, buying new weapons, all these would fall here, okay? You cannot expect a state to do it from one day to another. It takes time.
Where is the security, equality?
Security, what do you mean? Right to safety, I would associate it with life, okay?
Yeah.
Or home, it would be, it will have to go under one of the classic labels. And then it will develop effects here.
It's not equality. Health, education, and security parts.
Social security.
Social,
welfare state.
Yeah.
Yes, this would fall here. Like insurance and stuff like that.
No, I think it's stuff about policing and prison.
Policing. These would be associated, for instance, with the right to life or with the right to property. So safety per se doesn't help me much. But if it is safety to protect my life, it is right to life. If it is safety so that they are not stealing your property, it is right to property.
The obligation of the state to provide security for the society.
This, okay, so safety, in my logic, would be associated with the right to life, the right to property, and then it would develop effects under all three layers. There would be a negative one. Policemen should not kill you. This is a safety issue. Policemen should not get into your house. The state should not take your factory. This is negative. The state should protect you when other people are getting into your home, when other people are threatening to kill you. How? By having the police, by patrolling, by etc. This is a positive. And fulfillment, the state needs to do its best so that it can progressively be in a better position to increase its capacity to do these two effectively. Okay? Other differences.
So we were talking about on the tech side due diligence, so taking steps to achieve the results. It's the means to achieve the result.
Due diligence. And means. First of all, what is the opposite of that?
Arbitrariness. Arbitrariness.
No.
So abstaining from taking action.
Abstaining. So this is you are expected to abstain. Here we are expected to do what?
Active action.
Provide. Proactive.
To interfere.
Interfere, provide. Or in simple terms, don't do, and this one is do. Okay? Huge difference. This means that this is the duty of due diligence. What is the duty here? And due diligence means it's equivalent, it's sometimes even synonymous, that this is an obligation of means. This is an obligation of result. Anyone from China in this room? China? Yeah. China? Okay. I'm from Greece. Do you know where Greece is?
Yes,
Yes.
of course.
In Greece, what the rest of the world says, this sounds so Greek to me, so I don't understand. In Greece, we say, this sounds Chinese to me, okay? So I'm pretty much sure this sounds Chinese to you, or Greek, okay? Let's try to explain this in simple terms, okay? Respect and negative, in very simple terms. I expect the state, like in Leila Sahin, not to do something. Not to ban headscarves. Not to get into my house. Not to kill me. Not to torture me. So the state, simply enough, needs to abstain, to refrain from doing something. What is this something? To refrain from causing a result. Negative obligations, or the duty to respect, is an obligation of result. Just take notes. Important term. Negative obligations are obligations of result. The state is expected to guarantee the result. The result is that I continue to live and I'm not dead. That my home is not violated. Okay? This is obligations of respect, or negative obligations are always obligation of result. The state is expected to guarantee a result. And it is easy for the state to guarantee the result. The result is that you continue to live, right to life. Why it is easy for the state to guarantee it? Simply enough, in that case, don't kill me. Don't get into my house. Don't do something. Unless if this is necessary for general interest, and this is where proportionality comes into play. Clear? Yes? Fine? So in this case, it is simple. The state should abstain from doing something, should abstain from causing an illegal result, a wrongful result. Life, torture, etc., etc. In this case, what we expect the state to do, in very, very simple terms, is to be a good doctor. Okay? Imagine you have suffered an accident. Okay? Can you say that this has been caused by the state? Imagine you're involved in a road accident. Okay? Is this caused by the state?
Can be remote way.
A remote way. Why remote way?
If the state doesn't take necessary step to avoid this sort of
Avoid.
inevitable result.
Okay. But is it the state that crashed on you? That
No, not directly.
No, it is another person. It is another car. Clear? Like in Fedegeva, it is not the state that caused the pollution. It is another private entity. Okay? In that case, we go back to the state and we expect the state to be a good doctor. Okay? So forget the state for a moment. We are in a car accident. Okay? Someone is hurt, and we say, "Is there a doctor? We have an emergency situation here. Is there a doctor?" And someone says, "Yes, I am a doctor." Imagine the victim of the traffic accident dies. Could you say that the doctor is responsible for it? It depends. Any other reactions? Is the doctor responsible if someone dies in a traffic accident? The doctor just happens to be there and tries to help.
No.
No?
Unless they actively do something that is
No, they
really wrong.
Yeah, it's a question of negligence.
Yeah.
So, is the doctor responsible here?
No.
No. What did you say? Yes or?
I said
It depends.
Yeah.
And I'm saying yes, it is the doctor who is responsible? Okay, so there is no yes. We'll come back to the depends. The no people. Imagine the doctor says, "Well, I'm a very good doctor." Yeah, I would say you need to call the ambulance. And then he goes back to continue with his tea, with etc. Is that doctor responsible?
He should try to do something.
Should try to do something. Why? He has a duty, yes, okay. The state always has a duty. Okay.
Ethical obligation.
They have a legal obligation to do what? Do they have a legal obligation to cure the person? Or to do what is possible. This is exactly the logic of protection. The state did not cause the accident. The state did not cause the problem. The problem has been caused by another person, the factory, or by a general situation that cannot be personified. An earthquake, a natural disaster, an economic situation, an economic crisis like in Greece now, okay? So this cannot be attributed to a state directly. You cannot establish direct causality. You cannot say, "You did this to me." If you can establish direct causality, then we are here. And we say, "Don't do it, unless it's proportionality, etc." When we are here in that mindset, then the logic is, and this is what truly due diligence means. Due diligence means that we expect the state to be a good doctor. Being a good doctor means that you try to achieve the best result. Okay? It is not an obligation of result. You do not need to guarantee that the person will not die. The result is beyond your control. What you're expected to do is to employ the means that are available to you in order to strive, to try to do the best. Clear? Okay. Would you expect the same standards of diligence? The opposite of diligence is negligence, okay? Would you expect the same negligence applies in tort law, in criminal law, it's the same logic, okay? Would you expect the same standards of diligence by a doctor who just happens to be on a Sunday afternoon in the highway and there is a car accident, with a doctor who has an appointment for a surgery, he's in the hospital, he has all the apparatus, his assistants, etc. Who should provide higher standards of diligence? The second one. Why?
He had the duty to care, to take care.
They both have a duty of care.
The surgeon has an immediate duty of care because he's in that situation.
The duty is the same. What changes in the two scenarios I gave you?
The second one, the context.
The context?
He has everything to do the best work.
The person who is at the hospital has the means to go higher, to achieve better results. The first one doesn't have the means. He's in the middle of the street, There is no apparatus, there is nothing. It is just him, his knowledge, and his hand. His hands. Whereas in the second case, you have all the apparatus you can find in a hospital. Clear? Yes? Which means, are these standards the same for all states?
No.
No? Mm-hmm. What do you think, the rest of you? Hmm?
No, some states have more means,
Uh-huh.
to achieve things to a better standard.
Particularly the welfare states have more
Okay.
responsibility to.
The more advanced, the more developed states have more means. Okay? I'll give you an example in a minute just to see what I mean. Can we expect all states here to guarantee the same standards?
For the respect one.
Yes. This is an obligation of result. This is an obligation of means. These, in order to assess what I expect from you, I need to establish the context, the means that are available to you. If you're the United States, okay, and a rich, or the United Kingdom, a rich, prosperous country, etc., before Brexit, okay, then I expect you to do more to protect, for instance, refugees than if you're Somalia. Do you know Somalia? Are you from Somalia?
I'm not.
Where are you from?
Close enough, it's on the border.
Okay. Somalia, for people who have never been there, but what we read in the newspapers, is a failed state. Okay? No central government, no control over, and it's a very poor state. So, would you expect Somalia to offer the same standards of protection for refugees comparing to the United Kingdom? No. But, here, do you expect the same standards, the same conduct followed by Somalia in the United States? Yes. Why? It is simple. Don't kill. Whereas in that case, it's try to save my life. So, this is objective. All states have the same standards. This is subjective. I'm not insisting on due diligence because you will have some reading to do on due diligence for next week, okay, or in 2 weeks' time, I don't remember. But in order to establish that there has been a breach of the obligation of due diligence, you have in reality to make 2 tests. The first test is a test of knowledge. If I'm not aware that someone needs protection, then I cannot offer that protection. If I'm a doctor and I don't happen to be on the highway when the accident happens, you cannot tell me you did not protect that person. I didn't even know it. I was in my home sleeping. And the second one is ability, capacity. Was I in a position to help? Did I have the means to help? Okay? So, the mindset here is entirely different. And why it is important that we establish if a case is a case of protection or a case of respect? Simply enough because we expect different things and we apply different legal criteria in each case. Here, what we want to see is causality, direct causality, if the state directly caused something. And in that case, we say, well, did you produce an illicit result? Did you kill someone? Did you prohibit him, her to manifest his, her religion, like in last week's case? Yes. And then we proceed with proportionality. We say, okay, were there good reasons to justify this? Yes or no? Here, the logic is different. Is there a problem? Yes. Was the state a good doctor? Yes, because it knew and because it could have helped. But the state performed at a lower threshold, like in Fedegeva. Then again, we go back to proportionality, like here, and we say, are there good reasons why it performed at a lower threshold? Are there general interest reasons that justify this? Yes or no? In both cases, we end up with proportionality. But before that, the logic is entirely different. I could go deeper into the comparison and move, the next point, I'm mindful of time and I want us to discuss Valianatos, but the next point, I'm just giving you some food for thought, we will not discuss it now. Is there an economic cost for this one? Does it cost any money to the state?
Cost. It does.
Why?
Because it's the state to ensure the enjoyment of that right meaningfully. And for doing so, you have to create legislative, judicial, and administrative environment. You have to ensure certain things that involve costs.
What you're saying is absolutely right. The difference is that they are either here or here.
For there?
For there, it's nothing. Don't kill me. Don't get into my house.
But states hands off.
Hands off. Yes, you have to make sure that there are regulations so that if a policeman kills me, he gets punished, etc.
Overlapping.
But no, not overlapping. We have moved to the second layer. This one has zero economic cost.
I don't. Yeah. Maybe there is two different. Like in developed countries, this is not real.
Why?
Because there is a cost for, like, the policeman should be really prepared for doing that.
Doing what?
It's like
not to
we
kill.
have a lack
Not to kill.
between people who are educated and the others who are not educated. And sometimes it's very difficult to live with these differences.
I see your point, but in that case, we would go here. You have to take measures so that in the future, etc., etc. But as such, this is an objective standard for all states. States should not kill people. This costs no money.
Okay, but...
What costs money is you need to educate them. We would put this here. You would need to have legislation, you would need to have courts, you would need to have that they will punish people, etc. All these are in reality means for prevention. Protection has mainly two aspects, it's prevention and punishment. Everything that has to do with prevention and punishment goes here or here. So my point here is that this has zero economic cost. Whereas this one, because you have to educate policemen, you have to pass laws, you have to build hospitals, you have to buy all the medical equipment that people need, you have to clean the water, you have to take, you have
to
everything.
Yeah, I think it's a really
okay.
Like that for developed countries. So.
This has an economic cost. And this raises huge issues with regard to the legitimacy of judges. Because if a court, and we will see cases like that, I'll give you a case where the European Court of Human Rights said that each and every refugee, not a refugee, before they are given the status of a refugee, when they are getting unregulated migration and then they apply for a refugee, each and every person is entitled to free accommodation. Can you imagine this for the economic cost of this? So you have a judge who says, for me, protection means everyone gets a free house. Can you imagine this cost for thousands of people? This can really destroy the budget of a country. Which means that the money you give all these rights, as you said, it is everything. And all these are competing. Why? Because they have limited resources. If the money I will give for police training is money I will not give for education. The money I will give for education is money I will not give for child abuse. Which means that this requires also establishing priorities. And the question is, who has the legitimacy to establish priorities? Is it a question for judges, or it is a question for the parliament, for the people, to directly say, well, I want free education, but I don't want free NHS. We will discuss this when we will be discussing social rights as well in more detail. So economic cost, no economic cost, plus issues of legitimacy. And this is where fulfillment comes. Fulfillment, the big difference with those two is that fulfillment is not actionable before courts. You cannot go before a court and say, well, my state did not have a sustainable, they did not put an agenda 2025, and by that time we will have reached that level of eliminating poverty or providing clean water to everyone. This is a political decision. This is political. This is programmatory. Whereas this one, when we fall under protection, judges have the right to set standards. And sometimes the line between those two is blurred. Sometimes there are issues that one might say, these are political questions, these are not for courts. But courts and judges will say, well, for me, because of human dignity, because of, equality, you should do this. But this costs money, okay? But we will have the opportunity to discuss all this again in the context of civil and political versus socio-economic rights. For now, what I want you to remember is that there is a key distinction. First of all rights, irrespective of whether they are social or economic or political or civil, they develop an effect under respect, protection and fulfillment. First thing. Second, all cases where we have an indirect horizontal effect, individual versus individual, fall here. Third issue. In order to distinguish between the two, the question to ask is who? Who caused the problem? If this has been directly caused by the state, we are here. If not, we are here. Fourth point. Once we have established whether we are employing the tools of respect or protection, that means an entirely different mindset. Why? Because this is an obligation of result, a negative obligation of result, and this is a positive obligation of means. Obligation of means due diligence, and in order to be in a position to establish responsibility, I want you always to think in terms of who is a good doctor. What could you reasonably expect? It is a test of reasonableness. What would you reasonably expect a state to do? Question?
I had a question as to what you said that under the fulfill category they're not justiciable, which I find a little bit problematic, because if some of the measures under fulfill include, for example, making budgetary allocations or legislative measures, then in a situation where, for example, budgetary allocations have not been made to doctors and doctors go on strike, and as a result there's a huge violation of the right to health, that is still justiciable, because persons can go to a court against a state.
It's an issue of protection.
But when you said that budgetary allocations fall under fulfillment, that is still justiciable, because they can be challenged in court.
Protection has an economic cost, and this has, so those two, this might sometimes have an economic cost, might have zero economic cost. This always has an economic cost.
So how?
And what I said is that the line separating the two is really thin. Why? Because it is a matter of saying, well, I can reasonably expect you to do this, and the rest of it is at your discretion, it is a political decision. Where we put the line? What are the limits of judicial control? No clear answer.
So which part were you saying is not justiciable under fulfill?
This one.
What within fulfillment?
Everything that is not justiciable, for me, could fall under fulfillment.
But what is that?
Everything that is programmatory, everything that is political. But keep this, because in both covenants, what I'll give you concrete case studies, and you will see how the UN committees on the covenants have interpreted certain rights on the basis of this classification. For instance, I'll give you the right to water, and you will see what they mean by negative, positive, and programmatory fulfillment. And you will see what is the content of the right on the basis of this classification, and we can then have exactly the same discussion. Okay? I'm mindful of time, very, very quickly. Fadeyeva. I want to show you how what we have been discussing here is employed by the court. First of all, you remember that I told you due diligence requires A, ability, and B, knowledge. Sometimes knowledge is not given. It is not, we need scientific evidence. Fadeyeva is important also because of that case, because the court said, you're telling me that because of pollution, your health is suffering. Well, I need some evidence. I cannot accept this just because you're telling me. And the court says, for that purpose, I will use scientific knowledge, I will use scientific evidence, and the standards of proof beyond reasonable doubt should apply. Which means that, well, I don't want 100% evidence, I want to reasonably, to avoid having doubts as to what you are telling. No causal link between environmental pollution and the applicant's illnesses, in principle, but then they apply this scientific test. They say this is what is the data that the government gave us, but then they refer to a number of elements that allow them to conclude that indeed there is a link between the pollution and her health. It says the applicant did not suffer any special extraordinary damage, but even assuming that the pollution did not cause any quantifiable harm to her health, it inevitably made the applicant more vulnerable to various illnesses, etc., etc. So they say, you did not manage to convince us that there is a direct link between the environmental issue and your problem. So the state could say, there is no problem there. I'm not aware of any problem there. On the other hand, yes, I can reasonably accept that this made you more vulnerable. Then the next part in green has to do with the question of who is causing the problem. If it is a negative or a positive issue. This is what the court is asking here. And it says, the steel plant was not owned, controlled, or operated by the state. So this is not attributable to the state. It is a private company. Consequently, the court considers that the state cannot be said to have directly interfered with the applicant's private life. So this is not a negative case. It is not something that has been caused by the state. It has been caused by another individual. Which means that the state has a positive duty to take reasonable and appropriate measures to secure the applicant's rights under the European Convention. Me as a lawyer, when I read this, I have departed from respect, and my mind is prepared for what we discussed under protection. So I have situated my mind in the second strand. So this is a case about what can reasonably be expected by the state in order to prevent and put an end. This, in my mind, in red, means due diligence. The court concludes that the authorities in the present case were certainly in a position to evaluate the pollution hazards and to take adequate measures to prevent or reduce them. This is the test of due diligence. Did you know? Scientific evidence. Second, were you in a position to do that, to be a good doctor? Yes, you were in a position to do that. And then the court applies proportionality. It says, yes, you knew that there is a problem. Yes, you could be a better doctor. Let's see if there are any good reasons, proportionality, justifying you not being a good lawyer. And says, the court reiterates that whatever analytical approach is adopted, positive or negative, proportionality applies. Because of due diligence, this is in red, the state has discretion to choose the means. So it is an obligation of means. This means that the state, if there are various pertinent means, will have the discretion to choose the ones that are fit for purpose and which it prepares. And then, I will not go through it, they go through proportionality, and they found that the state breached its obligation. Okay? It is not the court's task to determine what are the exact means that should have been used by the state, but what the court can do. So, I will not tell you shut down the corporation, I will not tell you adopt X legislation. This is your job as a state. You're free to do whatever you want as long as you demonstrate due diligence. You do the best you can in order to protect that person. Okay? In the same way, you have exactly this in logic. The European Court of Human Rights is very rarely using the term due diligence, but you will find the term due diligence is always associated with positive protection. You will find this much more in the case law of the Inter-American Court of Human Rights. The Inter-American Court of Human Rights, next week you will have a judgment of the Inter-American Court, is the twin brother of the European Court of Human Rights in Latin America. And in that case, the court, make it. In that case, can anyone summarize really quickly the facts of the Velasquez judgment? This is a case of forced disappearance. In Honduras, in a magical way, people that the establishment did not like, they would disappear. Okay? No one would know where they are, if they have been killed, tortured, if they are imprisoned, they would disappear. So it's forced disappearance. And in that case, the court said that, okay, I don't know if this has been caused by the state or not. I believe it is the state, but even if it is not the state, you still have a positive duty. And this is associated with due diligence. So, however, this does not in principle, any violations of rights recognized by the Convention carried out by an act of public authority or by persons who use their position of authority is imputable to the state. Okay? However, this does not define all the circumstances in which the state is obligated to prevent due diligence, investigate and punish due diligence, human rights violations, nor all the cases in which the state might be found responsible for infringement of those rights. An illegal act which violates human rights and which is initially not directly imputable to the state, so it has not been directly caused by the state, can lead to international responsibility of the state, not because of the act itself, but because of lack of due diligence, because the state has not been a good doctor. What is decisive is whether a violation of the rights recognized by the Convention has occurred with the support or the acquiescence of the government, or whether the state has allowed the act to take place without taking measures, obligation of means, to prevent or to punish those responsible, due diligence. Reasonable steps, etc., etc., due diligence. The duty to prevent includes all those means of legal, political, administrative, and cultural nature that promote the protection of human rights, etc., etc., etc. So this has to do with the idea that as a state, to protect, you have to do, practically speaking, everything. Okay? Adopt laws, educate your policemen, buy them new equipment, etc., etc. The time is over. I was hoping that we could also discuss Vallenatos. I'll keep this in mind, and I'll have to discuss it with our guest speaker next week. Either we take 10 minutes to discuss Vallenatos, or I keep it aside, and in the next occasion that we can discuss the effects, the difference between negative and positive, I will raise it. Any questions? Any questions? Okay, then what I'll do is I will send you today please sign a register. Can you circulate the register, and you put please your email address. I will email you by this evening with the reading for next week. I keep chasing the University for the Vital, but this is still not working. It is not the law school, it is central, it is anyways. I hope it will work soon. I will circulate again the handbook for those of you who joined the class last week and you do not have access to